Hello and welcome. I am Lian Buan and this is Rappler Talk. We're here today with the Presiding Justice of the Anti-Graft Court, Sandiganbayan, Justice Geraldine Econg, who has been a justice here for over 9 years and was appointed to be Presiding Justice of the Court by President Ferdinand Marcos Jr. last January. PJ, maraming salamat sa oras niyo po.
Thank you, Lian, for this opportunity to talk to you and to talk to the public, no? In general.
PJ, diretso na ako kasi when it was time for PBBM to appoint the PJ of the Sandiganbayan, yung nagko-confound sa utak ng mga tao, korte ito na nag-handle ng mga ill-gotten wealth case laban sa kanyang pamilya, and yet he gets to appoint who gets to be PJ, kung sino yung mga uupong justice. How would you like to explain that to the public? How will the court be independent kung yung appointing power nila, sila mismo yung defendant?
Okay. You have to look at the power of the President under our Constitution. Only the President can appoint members of the judiciary. And by appointing a member of the judiciary, not just here in the Sandiganbayan, but also the judges of our first and second level courts, yung ating mga judges ng Municipal Trial Court, judges ng Regional Trial Court, pati na sa Court of Appeals and sa Supreme Court. Ito ang mandato ng ating konstitusyon, na ang presidente lang po ang merong kapangyarihan na mag-appoint ng judge o justice man. At ginawa ito ni Presidente Bongbong Marcos kasi ito ay katungkulan niya at hindi dahil siya ay may mga kaso na nakabinbin sa mga korte. Sabihin na natin na meron mga kaso ang pamilya ni Presidente Marcos dito sa Sandiganbayan. Pero hindi lang sa Sandiganbayan ang mga kaso ng kanyang pamilya. Meron din sa Supreme Court. Ibig bang sabihin na questionable din ang pag-a-appoint ni Presidente Marcos sa Justice ng Korte Suprema? Hindi. Kasi ginagawa lang niya ang kanyang katungkulan. Iisipin natin na ang pagpili ng isang mahistrado ay isang mataas na proseso, mahabang proseso ito. At ito ay nagsisimula sa Judicial and Bar Council. Walang kinalaman ang desisyon o walang impluensya ang ating Pangulo sa Judicial and Bar Council process. Kasi ito ay pinamumunuan ng ating Korte Suprema. Sila ang pumipili, nagve-vet, nag-shortlist ng mga tao na pwedeng i-appoint ng ating presidente. So with that, I think the objectivity in the process of appointment is still maintained.
Justice, among yourselves, kayo sa Sandiganbayan, meron ba kayong pep talk sa isa't isa na, just do your job, whoever the president is?
We are all aware that the presidents come and go. But we are here to serve until the age of 70. So, because of that, and because of our sworn duty to defend the Constitution, to do what is right, to dispense with justice, to hear every man's plea that comes before us, we are always mindful of our jobs.
Since nga pong naupong presidente si Pangulong Bongbong Marcos, lahat ng resolusyon o desisyon na lumalabas sa korteng ito really is wanted by the public. Gusto nilang basahin, lalo pag katulad kay PBBM. So what I did was I looked at the available decisions and resolutions, and what I found you can clarify later is that from Pinoy to Duterte, which is 12 years combined, 12 lang po ang napanalo ng mga Marcos-related cases. That's both for the family and the alleged cronies nga. But from 2022 to 2025, in only 3 years under PBBM, 11 na po yung kanilang napapanalo. Doon muna po tayo. In general, how would you siguro assuage the fears and doubts of the public na, biglang dumami yung panalo simula nung naupo siyang Pangulo?
Okay. Kung titingnan natin yung numbers, no? And that can be verified by everyone, by the public, because all our decisions are public. As i-plug ko na lang ito din, Lian, no? Lahat ng desisyon ng Sandiganbayan, pwede pong matingnan, ma-access sa internet kasi available itong lahat. So itong lahat na sinasabi ni Lian, itong lahat na sinasabing dating na desisyonan sa time ni Presidente Aquino, time ni Presidente Rodrigo Roa Duterte, at kay Presidente Bongbong Marcos, makikita nilang lahat. At yung pagkabilang ni Lian, masosuportahan yan sa makikita nyo. At totoo, may mga desisyon kasi na lumalabas from the Sandiganbayan in 2020, span of 22 to 2025, na kung titingnan mo, the numbers would say marami. But if you look at these cases, a lot of this involves case number 033. It's only one case, and that involves
The Coco Levy cases.
the Coco Levy Fund. We are not unfamiliar that the Coco Levy Fund has been decided by the Supreme Court and has gone up and down. And that decision of the Supreme Court was final. As a matter of fact, it has disposed with finality the shares of San Miguel and the Coco Levy Fund, the determination of whether this fund is public or not. What we are doing right now is getting from what the Supreme Court has said and implemented it below, because naturally the case decided from the Supreme Court comes back to us and we need to execute them. In those cases, the main defendant or the main respondent was involved and the case against him was already resolved. And as a consequence, the other defendants or respondents involved in the case, their cases will also have to be determined with finality. Hindi naman fair. Kaso presidente ang involved na hindi natin i-resolve ito. We are going to be unjust to him and his family kung hahayaan nating patutulugin ang kaso dahil isa sa mga defendants ay anak ng dating Presidenteng Marcos.
So you're saying, PJ, na inabutan na lang talaga sa panahong ngayon that these were due to be decided?
Yes. It's due to be decided, and a lot of these cases, kung titingnan mo kasi, bumaba from the Supreme Court and directed the Sandiganbayan to proceed with dispatch in the resolution of these cases.
PJ, let me zero in on 2 wins in 2024. Kapag binacktrack ko po yung records, si BBM po talaga yung nag-file ng motion to dismiss. As the executor of the estate, heir of his father, yung motion to dismiss niya po, yun, including the Coco Levy case, ay yung was decided in his favor by your division. And you were the ponente. Pag chronological po natin yung event, 2024 po yun, by January, na-appoint na po kayong PJ. So, what do you want to say to those who may perhaps unfairly conclude na, kaya ka siguro in-appoint kasi you penned a decision in his favor, granting his own motion to dismiss?
This I will pose as a challenge to everybody who wants to question the decision, particularly of the 2nd Division that I chair. Walang natutulog na kaso sa 2nd Division. Walang natutulog na kaso kung saan ako ay isang miyembro, kahit junior member ako or senior member o ngayon chair na. Kaya hindi fair, hindi makatarungan na hindi ko titingnan ang kaso na nag-move ang isang defendant who is, by the way, the president. Hindi factor ang kanyang pagiging presidente. But what is the factor there? And that concerns me is that there is a motion and that there are pleadings and we are time-bound to resolve them. I am very particular on the timeline of cases.
PJ, the Marcos cases, they're really so complex. Parang wala pa akong naisulat na Marcos case na hindi ako nalilito. And may mga decisions din na may mga concurring and dissenting opinion na nagpapatunay na nakakalito, pati sometimes kayo hindi nyo na alam yung computation, no? From your view, both as Associate Justice and Presiding Justice, ano ba yung naging challenge ng investigators and prosecution kung bakit pagdating sa korte, parang sobrang a web of cases na yun?
Okay, in these cases, these are the cases that are the civil cases that we have. Ang challenge talaga ng Sandigan is that these cases have been pending for a long time. And palagi siyang umakyat. Isang desisyon, isang order na lalabas from the court, iko-question, pupunta ng Supreme Court. Magtatagal, hindi na naman natin maaaktuhan kasi naghihintay tayo sa ruling ng court, kaya nagtatagal ang kaso. That is the challenge for us because every time the matter or an issue gets back, we need to study the case all over again. Now, in the criminal cases, those cases that are prosecuted by the Ombudsman, I would say the challenge really is the evidence presented, the witnesses that are available. When the case comes to court, witnesses are no longer available. The evidence that's left are mere photocopies. Some could not even be retrieved anymore because of the period that lapsed from the time the act was committed and the time when we start trial. So you shorten the time, then probably there will be more witnesses who are willing to come. There will be more witnesses who are available, witnesses who are not yet dead, or physically incapacitated to come or even testify, and that evidence will still be intact.
Justice, would you say, nasabi nyo nga, ang dami rin kasing defendants and respondents sa mga kaso na to.
Yes.
Factor ba nung delay ay ang dami kasi nila? Minsan, of course, defense lawyers would, sabi nga nila, they would file dilatory pleadings, ganun. Meron din bang ganung nangyari sa mga Marcos?
Yes. Lalo na, sa Marcoses, you're saying,
yeah.
There are so many defendants, and at this stage, the challenge really is to look for the defendants. Because, well, when some defendants are sent notices, they're not in their address anymore. The lawyers that are part of the case representing the defendants, you know they're dead, but that's a personal knowledge, no? So you have to somehow still go to their known address, serve it, although you know that they're already dead. So these are challenges.
Hanggang ngayon po, parang hindi pa rin magkasundo kung meron pa bang natitirang perang mare-recover kasi some decisions do not involve an amount or sasabihin ng PCGG, actually may compromise agreement na kami, kaya give up na tayo.
Yes.
In your estimate, milyon pa po ba yung pinag-uusapan natin?
Alam mo, in the cases that went through me, it's very surprising, you are right, merong mga compromise agreement na hindi ko naintindihan na binbin siya somewhere na hindi sinabmit sa court. So, if only we focused on them, we took a look at them, sana nalaman ng court kaagad na meron na palang mga compromise agreements ito. Of course, meron ding mga milyon doon sa mga compromise agreement na somehow executed already. No? So, in the cases that you have mentioned and probably you have seen, it's not just one that is dismissed or compromised there. So, we have a judgment by compromise agreement. And then there are also some cases, one or two, where the Office of the Solicitor General withdrew. So, you know, it's not, you cannot just say,
Kayo yun.
Ako yun. Because, maging ako na yon ang may problema, kung sabi na ng OSG na they have already settled, and yet I will say no. Because ang guideline natin, when a case is settled, if there is a compromise agreement, is for the court to issue a judgment by compromise agreement for as long as the compromise between the parties, meaning the defendants, including the family of the President and government represented by Office of the Solicitor General, is not contrary to public policy.
PJ, may mga dosena pa bang Marcos-related cases, would you say?
Meron pa rin mga related cases, but some of them hindi na involve ang Pangulo. Ibang members ng family or merong official during that time.
Has the President, as a President, come here for a hearing? Nakita niyo na po ba siyang nag-hearing dito?
Hindi siya pumunta as when he is President in a hearing. He has not come. I have not received any request, any call from the President or his family or his lawyers to help them dispose of the case. Walang ganun.
PJ, moving to another
Yes.
topic, you have confirmed you are applying for the ombudsman post. That is yet again another very controversial and politically charged post. Sa JBC interview pa lang, masuscrutinize na kayo, magpa-public interview kayo. And perhaps one of your most controversial ponensya was the acquittal of Senator Bong Revilla for plunder. So I take this chance kasi I don't believe you have addressed this publicly. Medyo strong yung mga dissenting opinions nila doon. So sa mga gustong malaman yung side nyo kung bakit na-acquit si Senator Bong Revilla pero may pinapabalik na pera, how would you simplify that?
Ganito yon. Actually, ang ponente ay si Justice Efren. So, ang ginawa ko ay nag-submit ako ng reflection. I did not dissent. I submitted a reflection. And the other one, Justice, sided with me. So that triggered a division of 5. One of the special members sided with us, and the other sided with Justice Efren. So my decision had to expand the reflection that I submitted. Naniniwala ako sa ebidensya. I did not say that he is innocent, but I said that he could not be proven beyond reasonable doubt that he committed the crime. That is a whole lot of difference. So, what I believe, and I still believe, that the prosecution was not able to sufficiently establish beyond reasonable doubt the commission of the crime. Because the evidence that was submitted to us was not enough.
I remember one of the things that I think Justice Estuesta, yung isang dissenting, sinabi niya na nakita naman yung disparity ng legal income dun sa AMLAC report that the wealth was never addressed. Para bang hindi na natin tinakel kung bakit may ganito siya karaming pera at that time. So, for the public na parang, oo nga naman, saan nanggaling yung mga perang pumapasok, di umano na sinabi ng
Yes.
AMLA?
Now, if you take a look at the AMLA report, and if you are going to read what I found, sinama sa AMLA report yung wealth of not himself, but of the entire family, including the income of the children, who are already of age.
Justice, yung 125 million na pinapabalik, marami ring nalito doon. In fact, parang pagka-promulgation kami rin nalilito kung kasama ba siya. Pero sabi doon, jointly eh. So, ano po, and we know that, I think status quo ngayon habang ina-appeal ni Senator Revilla. So, ano po ba yung rationale nun? Bakit kasama siya?
Now, hanggang ngayon, I would like to explain that, but until now, I'm very sorry. That's still pending in the Supreme Court. And I don't want to explain further because it might create or it might influence the Supreme Court. It's what you call the doctrine of sub judice. So I hope everybody can understand that we cannot discuss cases that are still pending before the Supreme Court. Natapos na po sa atin yan. Meron na kaming pananaw, pero yung pananaw namin ay under review pa or kailangan pang susuriin ulit ng Supreme Court kung tama ba ang aming nagawang desisyon. Kaya hindi muna natin pwedeng pag-uusapan hanggang ngayon.
Understood, PJ. So moving on to another pork barrel case, kasama rin po kayo sa nag-concur sa acquittal ni who's now the Chief Presidential Legal Counsel,
Yes.
Juan Ponce Enrile. Again, sa mga hindi po, kumbaga baka nagda-doubt ko, parang bakit naman na-acquit si Enrile? How would you want to address that?
Dito sa Enrile case, and I'm not sure if there was may appeal ba? Wala naman siguro, no?
We will check and include in the report kung meron
Yes.
po.
But in that case, I will just proceed with caution and think if there is an appeal or not. Well, proceed as if there's an appeal, no? This is a decision that was arrived at 4-1. Only one, the ponente wrote in favor of conviction, but the conviction was not for plunder. Ganito kasi, ang akusado, pwede siyang ma-charge for plunder, pero pwede siyang hindi ma-convict for plunder, but an offense which is included in the charge of plunder. So, ang sabi ng ponente, hindi siya plunder, pero lower offense, bribery. Ang sabi namin, parang nakakaduda na may bribery. Kasi, ang desisyon ay, ang ebidensya na pinipresenta ay hindi clear, hindi klaro na talagang meron yun at nagawa ni Enrile. Walang ebidensya na sinabi na tumanggap ng pera si Enrile. Walang ni isang testigo na nagsabi na tumanggap siya ng pera. So, because of that, we will always resolve in favor of acquittal. If there is an iota of doubt, we cannot convict.
Yung reasonable doubt na po.
Yes.
PJ, regardless kung sino yung allegedly nagbulsa, from the evidence that you saw, masasabi niyo po bang marami talagang nalustay na pork barrel in this entire case?
Let us look at this. I will answer that not just focusing on the two persons, Revilla and Enrile. But in general, I would say that money of government through PDAF was really mishandled.
And siguro po sa publiko parang ang daming na mishandle and yet wala tayong napanagot. How would you
I
explain
will
that?
disagree because we have convicted some
Janet Napoles.
of the legislators as well. There were legislators that were convicted. And that's on record. You can check that we have convicted legislators when evidence really pointed to them. So in other words, it's really based on evidence. Hindi kami mag-hesitate na mag-convict. Pero kung ang evidence nakakaduda, we will have to give it to the accused, whether he is a legislator or not, whether he is a mere lowly public official or not.
Which brings me to my next question, PJ. Should you be appointed ombudsman? Dahil alam mo na yung kakulangan nga ng ebidensya, ano yung parang una mong gagawin sa ombudsman para yung mga kaso ng prosecutor will really stand and will result in conviction?
Well, I might be, but we're just talking about plans.
Yes.
No? We are
Hypothetically.
Hypothetical lang ito. I think the ombudsman should speed up the filing of cases because the longer you take in the filing of the case, the less chance will the witnesses be able or be available to be presented. The lesser chance would documents be intact.
na ma-preserve.
Yes.
So yun po talaga yung mga naging problema, hindi na mahagilap yung witness or minsan nagko-cold feet na, gano'n.
Or nag-change na ng mind, lalo na pag magkatunggali sila sa election and they mend their differences, iba na ang kinakanta. And then, all of a sudden, if mag-drag pa dito yung hearing, come 3 years, nag-aaway sila ulit, iiba na naman ang kanyang testimony.
Second to the last question, PJ. If hypothetically you are appointed as ombudsman, would you be open to reviewing the policy that restricted public access to SALN? Mga 4 na taon na po namin hindi nakikita ang SALN ng public officials.
Okay. Regarding SALN, the law says public, no? Nagtaka ako hanggang ngayon kung meron bang pumunta ng Supreme Court
To challenge?
Wala naman. So, at best, that is just a policy of the office. And because it's a policy of the office of whoever is the incumbent, I think whoever is the next ombudsman will have the freedom to review that office policy.
Kung ikaw yun, PJ, you'd be open to reviewing it?
Yes.
Pwede mo namang sabihin kung ano yung tingin mo about it?
Let's start with, we will take a look at that and go back to the law. As you have said, no, Lian, you have taken up Master of Laws, and when you talk about anti-graft in the international level, magtataka ka, they all talk about prevention. Pero yung sa atin dito is prosecution. So, somewhere, there is a gap between what other nations are doing and what we are doing. So, maybe it's also time to look at their practices and examine why, for example, SALN did not work here, or did it work? So, these are the things that we would like to see.
Susugan ko yung sinabi mo, Justice, na sa iba prevention tayo prosecution. But would you...
Di ba you agree?
Yes po, but would you also agree, PJ, that successful prosecution is also prevention? Kasi
Of course.
deterrent yun sa mga magko-corrupt.
Of course. Successful prosecution is definitely deterrent, and it should be the most potent. But you have to make sure that when you prosecute, you should eye for the conviction and a high conviction rate.
Justice, last question, nasagot nyo na partly, but I'll just wrap up with this. Para sa mga may frustration, distrust sa justice system, sa judiciary, at minsan Sandiganbayan yung na-highlight because you handle public officials, what would be your appeal to the Filipino people?
Please give our courts, particularly the Sandiganbayan, a chance. We are trying our best to be transparent. We are trying our best for people to understand and see what we are doing. Our online services are there. It's in the internet. Our decisions are right away published. You are free to criticize us. Hindi kami mga onion skin because we're public officials. And we will look at your criticism, your inputs as valuable inputs to us to improve our services. At the end of the day, Sandiganbayan is a court. And as a court, we have our court users, and the most important of the court users are those who come to us to seek redress. Thank you.
Thank you so much. That was Presiding Justice Geraldine Faith Econg. I'm Lian Buan. Thank you for watching.